5 seconds to go. Start. Similarly, this court in Dhampur Sugar Mills Limited versus State of UP reported in 2007-8 SCC 338 held. In our judgment, mere use of word may or shall is not conclusive. The question whether a particular provision of a statute is directory or mandatory cannot be resolved by laying down any general rule of universal application. Such controversy has to be decided by ascertaining the intention of the legislature and not by looking at the language in which the provision is clothed. And for finding out the legislative intent, the court must examine the scheme of the act, purpose, and object underlying the provision, consequences likely to ensue, or inconvenience likely to result if the provision is read one way or the other, and many more considerations relevant to the issue. We may also refer to Section 8 of the Act 2013. Section 8 provides for the procedure to be followed when the claim of juvenility is raised before any court. Section 8 reads thus: whenever a claim of juvenility is raised before any court, or a court is of the opinion that an accused person was a juvenile on the date of commission of the offence, the court shall make an inquiry, take such evidence as may be necessary, but not an affidavit, so as to determine the age of such person, and shall record a finding whether the person is a juvenile or not, stating his age as nearly as may be. Provided that a claim of juvenility may be raised before any court, and it shall be recognized at any stage, even after final disposal of the case, and such claim shall be determined in terms of the provisions contained in the Act and the rules made thereunder, even if the juvenile has ceased to be so on, or before the date of commencement of the Act. If the court finds a person to be a juvenile on the date of commission of the offence under subsection 1, it shall forward the juvenile to the board for passing appropriate order, and the sentence, if any, passed by a court shall be deemed to have no effect. The plain reading of section 8 referred to above indicates that whenever a claim of juvenility is raised before any court, or the court is of the opinion that the accused person was a juvenile on the date of the commission of the offence, then it is mandatory for the court to make an inquiry, and in the course of such inquiry, the court may take such evidence as may be necessary, however, not an affidavit, so as to determine the age of such person. At the end of the inquiry, if the court finds a person to be a juvenile on the date of commission of the offence under subsection 1 of section 8, then in such circumstance, the court is obliged in law to forward the juvenile to the Juvenile Justice Board for passing appropriate order and the sentence. We may also look into section 48 of the Act 2013. Section 48 is in regard to the presumption and determination of age. Section 48 reads thus: where it appears to a competent authority that a person brought before it under any of the provisions of the Act, otherwise than for the purpose of giving evidence, is a juvenile or the child, the competent authority shall make due inquiry so as to the age of that person, and for that purpose shall take such evidence as may be necessary, but not an affidavit, and shall record a finding whether the person is a juvenile or the child or not, stating his age as nearly as may be. No order of a competent authority shall be deemed to have become invalid merely by any subsequent proof that the person in respect of whom the order has been made is not a juvenile or the child, and the age recorded by the competent authority to be the age of person so brought before it shall, for the purpose of the Act, be deemed to be the true age of that person. Section 48 referred to above talks about a competent authority, whereas Section 8 of the Act 2013 referred to above is in respect to the court. However, what is relevant to note is that in both the sections, that is section 8 as well as section 48, the word shall has been used. There is one another aspect of this matter. It is the High Court who thought fit to pass the order dated 21st February 2018, referred to by us in para 9 as above, directing the Special Investigation Team SIT to make steps for ascertaining the age of the respondent herein. It is pursuant to such directions issued by the High Court that a special medical board comprising of 5 medical experts on different subjects was constituted, and it is this medical board comprising of 5 medical experts whose report we are looking into so far as the approximate age of the respondent is concerned. When we have reached to the conclusion that there is no cogent and convincing documentary evidence on record as regards the date of birth or age of the respondent accused on the date of the alleged crime, then there is no good reason for us not to look into or ignore the medical report prepared by the Special Medical Board which is on record. Stop.